it was about. So I am not sure how to address it because I didn't know what it was in reference to.
Okay. Do you, is 2 weeks enough time for everyone?
That's fine.
Does that work for you,
Okay.
Ms. Gibson?
Yes.
Okay, so I'll set over the order on hearing from May 30th to 8/1/23 at 1 p.m. And I made a note, Ms. Baldwin, on your original order in hopes the clerks will hang on to it for that 2-week period. Okay, and is there another issue that we need to address?
Yes, we're also before the court on contempt.
If I may, before you begin, Ms. Baldwin.
Go ahead.
For the court. So I have been in the process for a while now of trying to obtain counsel. I had a scheduled consultation appointment with counsel that got unexpectedly rescheduled due to an illness. I had hoped to have representation for this hearing. I am set to meet with counsel later this week. So I would request, since we just set a matter over for 2 weeks, to set this over because I was prepared to have representation for this hearing today that, as I said, got rescheduled due to an unexpected illness. It's been very difficult, as I'm sure counsel and the courts are aware of, trying to get consultations with attorneys in family law matters.
I can't disagree with that. I'm sure appointments are difficult to come by. Ms. Baldwin, any objection to setting the contempt to 8/1?
Certainly do. Here's why. The contempt was originally scheduled for last week. Everyone understood that we were going to have that heard last week. That's why we put, if court recall, there was a restraining order. We put the restraining order on the same date. This was as the contempt filing because that was already sitting last week before the court. And I said I didn't care what judicial officer heard it, and Ms. Gibson said I want her as soon as possible. So last week we come before the court. Ms. Gibson, then despite having filed a response, basically says, well, I don't want it heard. That makes no mention of finding counsel, kicks it over to this week at her request for continuance. Here we are yet again. Again, she's filed her response. Nothing has really changed. Counsel may come in or may not come in. We don't know. But the reality is we're in a position where we've already had, this is the second hearing where we've come before the court on the contempt. Everything's filed. I think it's appropriate that my client receive relief. The children at this point are suffering very real consequences. And the idea that we put it out is not reasonable. My client, because of how we time these things, my client's already waited a month to have this heard. The idea that it takes 6 weeks to get a pretty straightforward contempt heard is reasonable. So we ask them to go forward.